Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In this video, we are going to discuss Section 54 and 55 of Bharatiya Sakshya Adhiniyam 2023.
Hello everyone and welcome. Today we're going to dive into Section 54 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section deals with a really fundamental concept, the proof of facts by oral evidence. And let me tell you, for anyone preparing for the Judiciary or APO exams, this section is absolutely crucial.
All right, so here's what we've got on the agenda. We'll start with a quick intro to Section 54, then get into the main rule of oral evidence and, really importantly, its big exception. After that, we'll look at a key case, see how the new law compares to the old one, and finish up with some solid tips for your exams. Let's get started.
Okay, first things first. Section 54. You'll find this in Chapter IV of the Act, and that whole chapter is all about oral evidence. Think of this section as the cornerstone, It sets up the most basic rule for how you prove facts in a courtroom using what people say, through witness testimony.
So let's look at the exact wording from the BEAR Act. It says, and I quote, "All facts except the contents of documents may be proved by oral evidence." It sounds simple, right? And it is. In plain English, it just means that in court, almost everything can be proven by having witnesses speak about it. There's just one big but, and that's the contents of a document. What's actually written inside a document is a different story.
Right, so let's really dig into this core principle. The main rule here is just so broad. Think about it. Any fact that's relevant to a case, whether it's something that happened, something someone saw, or even something someone said, all of that can be proven just by a witness getting up and testifying. This is literally the foundation of how evidence works in our courts.
Okay, to really get a handle on this, let's break down the key phrases. First up, we have all facts. So what does that mean? Well, it's pretty much anything the court is looking at, an act, an event, a statement, you name it. Then there's oral evidence. This is the classic courtroom scene, right? It's the statements witnesses make under oath about what they saw, heard, or otherwise perceived. And finally, the word proved. This just means you've established the fact in a way that satisfies the court.
All right, let's switch gears to what is arguably the most important part of this section, the exception. So we've established that oral evidence is the general rule, but it has one huge limitation. What is it? Well, you simply cannot use it to prove what's inside a document. So if the whole case hinges on what a contract says, or the details in a will, or the terms of a sale deed, well, just talking about it in court isn't going to cut it.
So how does a court decide? It's actually a pretty straightforward test. Let's walk through it. A fact comes before the court. The judge's first question is, hang on, does this fact have to do with what's written in a document? If the answer is yes, then bam. The law requires the document itself. You need to produce that piece of paper. But if the answer is no, then it's fair game for oral evidence. This all ties back to something called the best evidence rule. The whole idea is that the court wants to see the most reliable evidence possible, and when it comes to what a document says, well, the document itself is the best evidence, isn't it?
Let's make this real with a simple example. Imagine person A is walking down the street and sees person B steal a wallet. Now, the act of stealing that wallet is a fact. Does it have anything to do with the contents of a document? Nope, not at all. So, A can go to court, take the stand, and testify about what they saw. It's a textbook example of a fact being proved by oral evidence, and it's perfectly admissible under Section 54.
Okay, now for the flip side, the exception in action. Let's say we have a dispute between a landlord and a tenant about the rent. The landlord claims the rent is 10,000 rupees. Now, if they have a written rent agreement, the landlord can't just come to court and say, "Trust me, the rent was 10,000. The court is going to say, "Show me the agreement." Why? Because that document is the best possible proof of what was actually agreed upon. His words aren't enough when the words on the paper exist.
Now, this isn't just a rule in a book. It's a principle that our courts, including the Supreme Court, have upheld time and time again. To really see how this plays out in complex situations, let's take a look at a really important landmark case.
So the case is Rup Kumar versus Mohan Thadani. The big question before the Supreme Court was this: can you use spoken words or oral testimony to change what's written in a contract? And the court came back with a very clear, very firm no. They basically said that once you've gone to the trouble of writing everything down and signing it, that document becomes the only evidence of the agreement. You can't then come to court and try to use oral statements to contradict it or change it or add new things. This case is a perfect judicial echo of what Section 54 tells us.
You know, there's a fantastic old legal maxim that sums all of this up beautifully. Verba volant, scripta manent. It's Latin, and it means spoken words fly away, written words remain. And isn't that just perfect? It gets right to the heart of the best evidence rule. People forget things, they misremember, they get confused. But a piece of paper, it stays the same. It's a permanent, more reliable record. And that's why the law gives it so much weight.
Okay, this next part is super important for anyone writing exams. You absolutely have to know how the new law connects to the old one. So let's quickly track the change from the old Indian Evidence Act of 1872 to our new Bharatiya Sakshya Adhiniyam.
So under the old law, the Indian Evidence Act, this rule was in Section 59. Now, under the new Bharatiya Sakshya Adhiniyam, it's Section 54. And here's the most important takeaway. Nothing has changed except the number. The actual law, the substance of the rule, is identical. I'll say that again, because it's a classic exam question. The principle is exactly the same, only the section number is different. Make a note of that.
Now, you might be wondering, is there a punishment attached to this section? And that's a great question, because it's a common point of confusion. The answer is simple. No, absolutely not. You have to remember that Section 54 is a procedural rule. It's like a rule in a game. It just tells you how to do something. In this case, how to present evidence. It doesn't create a crime, so there's no penalty or punishment involved.
All right, let's bring it all home and focus on what really matters for you, the exams. How is an examiner likely to test you on this section? Let's get practical. Okay, listen up. Here are your exam tips. For the prelims, be ready for direct hits. They might ask you the section number straight up, or they might give you a scenario to test if you understand the exception about documents. It's all about speed and accuracy there. Now, for the mains, things get a bit deeper. A very common question is a short note on the best evidence rule, where you'll need to link it back to Section 54. And even more likely, you'll get a problem-based question, a whole story where you have to play judge and decide if oral or documentary evidence is the right way to go.
So, for a last-minute quick revision, what do you need to tattoo on your brain? Just these few points. 1. The section number is 54 of the new Act. 2. The core idea is simple. You can prove anything with oral evidence unless you're talking about what's inside a document. And 3. Remember the principle behind it, which is the best evidence rule. And never forget, this is a high-yield topic for both your prelims and your mains.
So, if there's one thing you walk away with today, let it be this. Oral evidence is the workhorse of our court system, but when it comes to the written word, the law puts up a shield. It creates this special protected category for the contents of documents, demanding the absolute best proof you can offer. And that one single exception under Section 54, it is, of course, the contents of documents. For more legal content focused on your judiciary, APO, and other law exams, please stay connected with us here at Ganga Education.
Today, we're going to discuss Section 55 of the Bharatiya Sakshya Adhiniyam 2023. This section covers a really fundamental principle of evidence law, the idea that all oral evidence must be direct. For anyone preparing for judiciary and APO exams, understanding this section isn't just helpful, it's absolutely essential. So here's our plan for this explainer. We'll start with the main idea, the rule of direct evidence. Then we'll dive deep into the text of Section 55 itself. After that, we'll see how it's applied in court with some real examples, compare the old law with the new, and finally, I'll give you some specific tips for your exams. All right, let's get right into it. You see, the entire law of evidence rests on a few key pillars, and honestly, none is more important than the rule of direct evidence. This isn't just a technical rule. It's the very foundation that ensures fairness and protects the entire integrity of our entire judicial system. And this crucial principle is written down crystal clear right here in Section 55 of the Bharatiya Sakshya Adhiniyam 2023. You'll find it in Chapter 4, which deals with oral evidence. The message of this section is loud and clear. Evidence has to come straight from the original source. This creates a strong barrier against what we call hearsay. Okay, so we've talked about the general principle. Now let's look at the actual wording of the law. We're going to decode the precise language of Section 55, breaking down the bare act so every part of it is perfectly understood. The section starts with this very powerful and non-negotiable command. Oral evidence shall, in all cases whatever, be direct. In simple terms, this just means that a witness's testimony has to be limited to things they have personally and directly experienced. Any secondhand information, what we call hearsay, is completely barred from the courtroom under this rule. So how does the law actually define direct evidence? Well, it breaks it down very logically based on our senses. If a fact is something that could be seen, the evidence must come from a witness who can stand up and say, I saw it. If it's a fact that could be heard, the witness must be the one who says, I heard it. If a fact was perceived by any other sense, like smell or touch, the testimony must come from the person who directly perceived it. And finally, if we're talking about an opinion, it has to be presented by the person who actually holds that opinion. So the most important thing here is this unbroken chain of perception. First, an event happens. Let's say a sound is made. Second, a witness perceives it directly with their own senses. And third, that very same witness comes to court and testifies. This direct, unbroken line is what makes oral evidence admissible. Now, while this is the main rule, it's worth noting that the section does have two specific exceptions or provisos. We'll touch on those in our exam right later on. But for now, just remember this core structure. Let's move now from the theory to how it all works in practice. How does this rule actually play out in a courtroom? Because understanding the practical side is what really matters, especially for your exams. Let's look at a clear example and an important judgment. Let's imagine a situation. A witness gets on the stand and testifies. I saw the accused commit the act. This is direct evidence. It's firsthand, and it's allowed. But now, what if the witness says, my friend told me that he saw the accused commit the act? This is a classic example of hearsay. The court will not allow this testimony because the person who actually saw the event isn't in court to be questioned. So why is the court so strict about hearsay? This quote from the famous case of Tepper versus Ars explains it perfectly. Hearsay is rejected because you just can't test its reliability. You can't cross-examine a story from someone who isn't there. The witness on the stand didn't see it happen, so how can we verify their testimony? How can a judge assess their credibility? You can't, and that's the fundamental issue. This principle was very strongly upheld here in India by the Supreme Court in the landmark case of State of Rajasthan versus Kashi Ram. The court held that to guarantee fairness and reliability, judicial decisions have to be built on the solid ground of direct evidence from witnesses who personally saw the incident. This is a very important case to remember for your mains answers. This principle can also be understood through a legal maxim, res inter alios acta alteri nocere non debet. It's a Latin phrase that means, a thing done between other people should not be used to harm a third party. For example, a conversation between person A and person B can't be used as evidence against person C who wasn't even there. This maxim perfectly captures the spirit of the rule against hearsay. All right, let's now put this section into its proper legal context by comparing the new Bharatiya Sakshya Adhiniyam with the old Indian Evidence Act. This is a common area for questions in exams, so let's pay close attention. So under the old law, the Indian Evidence Act of 1872, this rule was found in Section 60. In the new Bharatiya Sakshya Adhiniyam 2023, it is now Section 55. And it's incredibly important to remember that this is only a change in the section number. There has been no substantive change to the law itself. The core principle, that oral evidence must be direct, remains exactly the same. And here is another vital point to remember. Section 55 is a rule of evidence, which means it's part of procedural law. It tells the court how to handle evidence. It doesn't actually define a crime or an offense. Because of that, there's no punishment attached to Section 55 itself. Okay, let's get to the part that matters most to all of you who are preparing for your exams. How will this section actually show up in your judiciary and APO papers? Let's break it down. For your prelims, you can expect a direct question, something like, the rule that oral evidence must be direct is contained in which section? And the answer, of course, is Section 55. For your mains, you should be ready for a short note on direct evidence, or more likely, a problem-based question, where you have to identify hearsay and explain why it's inadmissible. The key concept to focus on is the rule against hearsay evidence. And as I mentioned earlier, pay very close attention to those two provisos, the exceptions for expert treatises and the production of material objects. These exceptions are prime material for tricky exam questions. So for a quick revision, just remember three things. First, the section is 55 of the Bharatiya Sakshya Adhiniyam 2023. Second, the core concept is that oral evidence must be direct, which means no hearsay. And third, the key case law is State of Rajasthan versus Kashi Ram. The exam importance for this section is very high for both prelims and mains. So, we have established the very strong rule against hearsay evidence. But let me leave you with a question. Is this rule absolute? Is hearsay evidence always inadmissible in court? Well, the law is smart. It recognizes that sometimes, even secondhand information can be very reliable. We will explore these fascinating exceptions, like the doctrine of res gesta, in our next explainer. For more legal content focused on judiciary, APO, and other law exams, stay connected with Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.